Do those ads for loans you see on late-night TV sound too good to be true? Well, they are. We'll talk about predatory lenders right now on The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
Have you ever borrowed money at an interest rate of 200 or 300%? You can. My guests are attorneys Norman Gugel, Senior West Virginia Assistant Attorney General, and Douglas Davis, of West Virginia Assistant Attorney General. Norman, Doug, thank you for coming in.
Thanks for having us.
High interest rate loans, predatory lenders. This doesn't sound like anything good.
Well, our state has decided that people should be protected from high interest loans. So really the maximum allowable interest rate for a regular old personal loan in West Virginia is 18%, and yet the industry, various lenders have found all kinds of ways to get around our laws and charge us way, way more, even up to 600 to 800% APR.
Annual percentage rate interest.
That's right.
Now, we talk about interest rates, and the legislature over the years has said that the maximum rate of interest that can be charged on a loan made in West Virginia by West Virginia lenders to West Virginians is 18%, which is a very high interest rate.
It is high.
We used to refer to that as credit card interest rates, except that that'd be kind of middle ground for a credit card interest rate now. And to go beyond that is what?
Oh, we call it usury. I mean, if there are certain kinds of loans where the interest rate can go a bit behind it, but at some point, if you go above the legal limits, that we call it usury, and there are very stiff penalties under the law for usury.
What kind of penalties generally?
Well, actually, we have a statute that says if a lender has made a usurious loan, the penalty is 4 times the amount of interest agreed to be paid. And that doesn't mean the amount of interest actually paid, but whatever amount the consumer was expected to pay according to that written contract. So that's a huge penalty.
So if it was a 10-year loan at 20%, it would be 20% of the loan principal times 10 years. That might be more than the loan amount. In fact, it probably would be.
Yeah.
Oh yeah, definitely. Multiple times.
So lenders in West Virginia and other states with usury laws tend to obey the law. Well, usually. Well, banks and people like that try to do it right.
That's right.
Mistakes have been made, but
our West Virginia-based lenders absolutely obey the law. I shudder to think absolutely they do obey the law. The problems come in from companies based out of state who are looking for a way to evade our law.
And therein the problem that we're talking about here.
They could be they typically are located in states that have no usury laws. And then they take the view that because they're headquartered, for example, in South Dakota, Nevada, or Delaware, or a state that has no usury laws, they take the view that they can lend to our West Virginians and charge whatever they want.
Can they?
Oh, if they're a bank, actually they can.
If you look at that very small print document or documents that come with your credit cards or just show up in your mailbox from the credit card company every so many months, you will find in there someplace that the credit card banks are not the bank on the corner where you went down and applied for the card. They contract with out-of-state banks who issue the cards and administer the accounts. So the card may say hometown bank on it, but it's going to be typically a MasterCard, a Visa card, something like that, and it will be through a bank somewhere else. Now, what were the states that have no limits or have very high limits on interest rates?
Well, I think that, the majority of states probably have no usury laws. Is that true, Doug?
About half don't have the
That
usury
many?
laws now, right? But the ones we hear most frequently are Delaware, South Dakota, Nevada. And if you look on the bottom of your credit card, you'll see that's frequently where the banks are located, where the cards are issued.
And you're charged interest rates typically in the neighborhood of 18%.
No, no.
No?
Oh, no, most of these cards are going to have much higher interest rates in the 20s, and if you get into a default range, I've seen them up into the 30% range, 30, 35, 39%.
My heavens. It pays to shop around. I know I have an American Express card through a bank that I'm associated with in Texas, and the interest rate on it is a very attractive interest rate, single-digit interest rate, and I'd frankly love to use that card.
Well, that's because you have stellar credit. And
Well,
you get those rates.
we could talk about that, but apparently I live in North Carolina and had a contract with a cable company, and I owe them $60 because it's on my credit report. That's another program, How to Fix Your Credit Report. I'm going through that purgatory right now. Well, Norman, the debts that we're talking about here, I have sometimes referred to these as debts that never die. How do these things come about, and what does that mean?
Debts that never die. Well, we consumers, we're pretty good at creating debts, and we've had a lot of help from the credit card industry in creating debts. And it's not too hard to get way over your head, particularly for using credit cards. But in the olden days, and this is something we'll probably get into in another program, but in the olden days, banks would try to collect the debt for a while, and then if they couldn't, they'd use an outside collection agency. And nowadays, they will sell the debts to debt buyers. And sometimes, unfortunately, there's a lot of unscrupulous debt collectors out there, and sometimes even when people pay debts, other companies pick up the debt and try to collect it again, and that's a great problem.
Well, we talk about selling debts. What does that mean? Let's say, for example, Norman, you have borrowed $10 from Doug, and Doug is in the business of loaning money, and now he wants his money back, but you can't pay it back. You don't have that $10. What does Doug do?
What would Doug do?
Well, what Doug typically does is, if the debt collection agency doesn't work, and I've got the loan back, I will sell it to the debt buyer. I can't get a whole lot of money for it. I would like to get 70–80% of the value for the loan, but that doesn't happen. And depending on how many times it gets resold and resold, I could end up accepting as little as 5 cents on the dollar for the actual debt. I've heard it sometimes even goes lower than that if it's really old, aged debt, like a penny or two per dollar.
We're talking about predatory lenders. My guests are attorneys Norman Gugel, Senior West Virginia Assistant Attorney General, and Douglas Davis, West Virginia Assistant Attorney General. I'm Dan Ringer, and this is The Law Works. So somebody is willing to buy the debt for the opportunity to collect it.
Right.
Now, the debt in this example is $10. Debts that small, we probably wouldn't see this happen to. But you, the lender, would sell it to a third party,
right,
for whatever you could get.
About 10 cents.
10 cents on the dollar.
Right. No.
Just 10 cents?
10 cents. We're talking about $10 here. You're right. I'd maybe get 10 cents for it. Maybe 20 cents.
What if it was $10,000?
If I can do the math quickly enough, $2.
That is so these lenders sell large blocks of debts.
Usually hundreds at a time.
And the company, the entity that purchases the debts, now try to collect them.
Right.
And if they can't collect them, what happens?
Well, when they go about collecting, they start with the hundreds of phone calls, if they can get away with the hundreds of phone calls, which, the case that we just tried, they couldn't, and we secured a large judgment against the company. But they send letters. Sometimes they'll send people around to your house. If they totally strike out and they can't collect anything from you, they turn around and resell it.
They sell it then to somebody else.
They do.
For less than they paid for it, probably.
Right. That's right.
They'll try to.
And this can go on and on and on.
It could.
To the point where you're getting next to nothing for it, but you're getting something if you sell enough loans.
Right.
So whoever's selling it will make a few dollars, sort of, and that company will continue to try to collect.
Right.
But it's not always a matter of, okay, I'll pay the debt and it goes away, is it?
No, no. In fact, we get people calling our office with debts that are, 10, 11, 12, 15 years old that people are still trying to collect. And in West Virginia, you can't sue somebody after 10 years on a written contract. So these debts are essentially time barred, and they're still trying to collect them.
When you refer to our office, you're talking about the Office of West Virginia Attorney General Darrell McGraw.
Right.
And that's the Consumer Protection Division within the Attorney General's office.
Right.
If you're having a problem like we're describing here, you may want to talk to somebody at the Attorney General's office in the Consumer Protection Division. You can call them at 1-800-368-8808. 368-8808 and ask for the Consumer Protection Division, or you can go online to the internet on the West Virginia Attorney General's webpage at wvago.gov, wvago.gov. That's West Virginia Attorney General Office.gov. And you get lots of phone calls about these things.
We do.
So the debt is out there, it has been sold, people are calling, but you paid the debt off, or it's time barred. What does time barred mean?
Well, we have laws, we call them statutes of limitation, and that means that after a certain period of time, you can no longer sue to recover your money because the law decided that's just too long a period of time. People move on, they lose documents, they die, witnesses die. It's just too late. So you're cut off.
When you talk about you can no longer sue, you're talking about the debt collection agency.
The debt collection agency, the creditor, they've got 10 years to do that from the last time you paid the debt.
So if I had a credit card and I was making payments on it up until January 1st, 2000, and then stopped and there was still a balance owed, I could be sued until January 1st, 2010.
That's right.
And after that, can I be sued?
Well, you could be sued, but the attorneys that would bring that case and the creditor would be facing some repercussions from the court and perhaps from the State Bar Association for bringing a lawsuit that you knew you couldn't collect on.
What some of these debt buyers do, Dan, is they purposely buy very, very, very old debts, including debts that they know are over the statute of limitations. And then when they begin collecting, the first contact from a debt collector is almost always a telephone call. And they begin very, very aggressively, hoping to persuade you that if you don't give them a payment over the phone immediately, horrible things are going to happen to you. When in fact, probably nothing's going to happen. But if you fall for that and you make that first payment, then you have renewed the statute of limitations. And then the debt that was time barred, arguably, is no longer time barred.
So if they call you up on a really old debt, maybe 8 or 9 years old, or 9 years and 11 months old, and say something like, Norman, I want to help you out here. You owe this debt. You owe a lot of money on this debt. Just send me $1, just so I can say I got something, and I can convince my bosses to either leave you alone or just accept $1 for a while until they've got enough money. Would you do that for me?
You've just convinced me. In fact, your
Yeah,
approach,
you sound like you're in the business.
coming on soft,
No, I'm not.
coming on more softly as you did, as opposed to aggressively, would probably be very effective. And in fact, the debt collector could say, look, if you just make one payment now, we will work with you and try to get a dramatic reduction on what you owe. Just just make one payment now so I can show my boss you're showing good faith. And when you make that one payment, you're probably doomed.
Because you just renewed the time period for another 10 years.
Right.
Right.
But now if somebody complained to us and we learned that unfair pressure had been put on the consumer to make that one payment, we will view that as an unlawful tactic and try to undo that. But that's how they go about collecting these time-barred debts.
Most people want to pay their debts. Most people who can't pay their debts feel guilty about it. And, well, I see these loan offers in the middle of the night on TV. Why do people do that? In fact, one classic case, a few years ago, the gentleman who fronted for these ads has passed away since then, but there was an actor named Gary Coleman. He had been a famous, very famous child actor on a show called Different Strokes. And I turned on my TV one night, and there was a much, much older Gary Coleman telling me what a wonderful deal I could get on a loan, and they would have up to $10,000 in my bank account overnight if I would borrow from them. And a lot of people did. There were problems with that. That company was what?
That was Cash Call.
Cash Call. In theory, you called them and they sent you cash.
And they did.
And they did, yeah.
What went wrong?
Well, what Cash Call was doing, and it was true, if you applied for a loan from Cash Call, you didn't have to have a great credit. You had to have a checking account. You had to have some income. You didn't have to have a lot of income. You had to have a pulse. And that was pretty much it. And if you met their guidelines, they would loan you. It could be anywhere from about $1,000 to $5,000. I think in some states you could possibly borrow more. Right. And this was all done over the internet. And you would do it on your computer, either at home, or some people did it on their work computers. You had to give them your checking account information, and you were required to give them permission to take the payments out of your checking account.
An automatic debit against your checking account. That's right.
So you signed up, and if you were approved, they would electronically deposit the money into your account, sometimes within 24 to 48 hours. And then after that, they would electronically debit the payments from your checking account.
We're talking about predatory lenders. My guests are attorneys Norman Gugel, Senior West Virginia Assistant Attorney General, and Douglas Davis, West Virginia Assistant Attorney General. I'm Dan Ringer, and this is The Law Works. Well, that sounds like an easy enough way to do it. What could possibly go wrong?
Well, let me say, by the way, I mean, we just described how Cash Call operated. That's also true how an entire similar industry operates called the Internet payday lending industry. They make smaller loans, usually for maybe $300 to $500, but it's the same way. It's all over the Internet. They deposit the money into your checking account. They take the payments out of your checking account. The problem with Cash Call is, although consumers went to Cash Call's website to get the loan, the loans actually, according to the paperwork, were being made by a bank in South Dakota. And the reason it was set up that way was so that if the loan really was being made by a bank in South Dakota, then they could charge whatever interest rates they want.
South Dakota being one of the states that has no usury laws.
That's right, because the interest is governed by the law of the state where the bank is headquartered, not the law of the state where the borrower lives. So that enabled Cash Call to make loans in every state, even states like West Virginia that had fairly strict usury laws. The problem was when we got to looking into it and we started receiving complaints. Of course, when we saw complaints about loans with interest rates as high as 99%, we wondered, well, how can you do this? Cash Call isn't a bank, so they wouldn't be allowed to do that. But a closer look showed that the the loan on paper was coming through a bank. But we then looked even more closely, and we reached the conclusion that this relationship between Cash Call and the bank, that when you really looked behind the surface of things, in fact, Cash Call seemed to be bearing the risk of the loan, that the contract between the two of them made it seem as if Cash Call had all the risk and the bank had none, and all the bank was really doing, from what we could tell, was lending its charter, allowing Cash Call to use its name. Of course, the paperwork showed more. The consumers, when they signed up on the internet, the loan contract did say this loan is being made by the bank in South Dakota.
But it was really just being processed through the bank in South Dakota somehow, I guess. The money was actually coming from cash call.
Well, the money, as far as we could tell, the bank did initially fund the loan. So when the money was deposited into your account, it probably did come from the bank.
Right, but cash call would immediately pay the bank back on that day or a day later. So it wasn't like the bank was really at any risk because it was getting its money back almost immediately, 100 cents on the dollar.
So the bank wasn't depending on you, the borrower's credit.
Right.
They were going to be paid by cash call immediately, and then cash call, just like these entities that buy bad loans, cash call would then collect the loan from the borrower. It occurs to me that we perhaps ought to address very briefly the concept of interest rates. Norman said that interest rates could be as high as 99%. What that means is for every dollar you borrow, you have to pay 99%, 99 cents in this case per dollar, as interest each year. So if you borrow $1 and don't pay it back within the year, the next year you owe $1.99, and it keeps increasing like that. And different interest rates, of course, would add different amounts of money. So when somebody says, gee, an interest rate of 4%, 3%, 2% for a house loan, a mortgage, is good, that means that you pay 4 cents per dollar borrowed per year. It's not dollar borrowed, dollar still owed. You pay off the loan and the principal goes down. It gets to be very expensive, which is why when you see in full disclosure statements that the $10,000 automobile you're buying on this long loan is going to cost you $30,000 at the end of the loan, it's really costing you $30,000. That's the price of the car. Part of it is for metal and part of it is for interest on the loan that you're borrowing. Well, what did the Attorney General's office do about all this?
Well, you know, we always try to settle cases, and we started this case like we started all of them. We almost always get complaints, and usually it takes a lot of complaints to get our attention before we will open what we call a formal investigation.
It has to be a real problem.
Yeah.
Right.
I mean, consumers were not only complaining about the high interest rates, but they were also complaining about some fairly serious debt collection harassment. And we got enough complaints that we started taking a closer look, and we concluded that we had to try to do something about it. You know, the early efforts to try to resolve it without litigation really didn't succeed. So, and we are really, believe it or not, very reluctant to have to take companies to court. But when we have to do that, we will. And that was what it came to in this case.
Do you get paid for doing this?
I hope so.
From the recovery, does the Attorney General's office get anything out of that, or the state of West Virginia?
We're just salaried employees.
Well, yes, you individually get paid, but you get money back for the borrower?
We try to.
Yeah, we try to. And in this case, the order is a lot of restitution should go to the borrowers. And there's also a penalty component that would get paid to the state treasury, and another component that I believe goes to our office.
The Attorney General's office, to fund these kinds of actions.
Right.
That's what a Consumer Protection Division does.
Yeah. And really, Dan, the goal in almost all the work we do at the Consumer Protection Division is to get refunds when consumers have been wronged in some way, whether it be in the purchase of goods or by a predatory lender. Our goal is to make it right, and that usually involves either undoing a sale that was deceptive or refunding money that was wrongfully taken.
If you'd like to contact the Consumer Protection Division of the West Virginia Attorney General's office, you can call 1-800-368-8808, or you can go on the internet to wvago.gov. That's the Attorney General's webpage. If you're in serious financial trouble and those loans late at night start to look good to you, you might want to go talk to a lawyer. You've got some options, bankruptcy, workout plans. There are all kinds of things that can happen. And the businesses with whom you do business would much rather discuss repayment under different terms than your contract says. Norman, Doug, thank you for being with us.
Thank
Thanks,
you.
Dan.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening.
If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the Law Works website at thelawworks.org, you'll find a listing of recent The Law Works programs, additional information about this show's topic, and video of this and recent shows. You can also find the Law Works programs on YouTube and iTunes.
The Law Works is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the Law Works is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.